Hey everyone, Harry here to talk about Mark Meadows back on the scene. Remember, he lost. He was the very first person to seek removal from the Fulton County proceedings, saying, I shouldn't have to be tried in state court. I should be able to go to federal court. And he lost that effort. And then it went up to the Court of Appeals. He, appealed it, and he lost there again. And he's been pretty quiet since. But remember, as part of the process, we did learn that he's been involved and has given testimony in the 1-6 case in D.C., apparently not with a cooperation agreement. But he has had to date the best lawyers out there, I would say, a former deputy attorney general and then a Supreme Court clerk type writing his papers. And he's been playing it unlike Trump or the others who are sort of crass and loud and undiscriminating about the whatever crap they'll put up there. He's been cautious and surgical. All right, now he's been quiet, but he comes back in play, and he asked Judge McAfee, he wants to now argue that the case should be dismissed because he has immunity, and he wants McAfee to convene an evidentiary hearing in order to give him a chance to prove he has immunity. And he says that there are a couple new documents that have been received in discovery since he argued for removal, and they, without explaining in the papers that we see, they advance his cause for immunity, and he should have an evidentiary hearing. Okay, first, a really interesting inside baseball point that I picked up on just as I was looking. I don't think anyone else has noticed this. George Terwilliger and this hotshot clerk work for a classic D.C. white shoe firm called McGuire Woods. But this motion was filed. Terwilliger is on it, but McGuire Woods is not. So Terwilliger very ostentatiously, if you know the how things work, is just a sort of solo practitioner in Virginia. So he has some sort of separate entity. And the hotshot clerk is nowhere to be seen. There's somebody else who's obviously helped Terwilliger with the writing. So something funky, I think, is happening or has happened at McGuire Woods, where they haven't wanted Terwilliger to put his name on this. I don't know if that's specifically about this motion and maybe its plausibility, or there's been another sea change. It is the case, we know this, say, with Trump, who he'll try to get, he basically can't get a lawyer at a big firm because all the partners say that their clients, general counsels of companies, would revolt if they took him on as a client. So is there some kind of, similar thing happening with the erstwhile establishment figure of establishment figures, Mark Meadows? Stay tuned for that. But it might also be because this motion seems so far-fetched because, look, it's been held against him on the evidence that he doesn't have removal. And I'll get to this in a moment, but the legal tests for removal and for immunity are, this far apart. But in finding against him, the court found expressly that what he was doing was meddling in state elections, and there's just no federal role for that at all. He's on the call to Raffensperger, which he's tried to say, this is just me holding the hand of the president. That's my 24/7 job. But A, that's dubious, and B, it doesn't account for a very, for him, unfortunate trip he took down to Georgia without Trump. And that was when there was browbeating of legislators and the like to essentially try to lie, I'd say, about the election. I think Giuliani's there, Jenna Ellis, and Mark Meadows is there as well. And that's what the district court pointed to specifically in holding, you don't get removal. Okay, so now he comes back and wants immunity. And we don't have to get too in the weeds here, but we are in the weeds in this sense. The test for removing a case and the test for getting immunity as a federal officer from state prosecution they overlap almost 100%. They're different a little bit in ways that you could say technically there's, a shaft of light remaining, but practically hard to say. And more importantly, it is easier to make the case, the very, 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 very similar case, but it's easier to make the case for removal than it is for immunity. In other words, having lost the removal argument, it seems to include the more harder to achieve immunity claim. So he starts out, with 3 strikes, maybe, 2 3/4. But, he'll try to say theoretically there's some space there. And McAfee, right, interesting, fairly methodical judge. And, he gave the evidentiary hearing foolishly, I thought, with the whole Fonnie Willis debacle. We'll see what he might want to do. But I just want to, I'm just turning to tell you that the relationship between removal and immunity, very overlapping, but under one prong, defendant just has to show they raised or will raise a colorable federal defense in order to get removal. Whereas to establish immunity, you have to have been engaged in conduct authorized by the Constitution, and you have to have done no more than was necessary and proper to effectuate that. That's, you're acting in your official capacity and you're not straying outside of it, versus you could raise a colorable federal defense. That's a sort of, one prong of it, but that means that it's easier to establish removal than it is immunity, and he didn't establish removal. So we'll see what McAfee does with this. It could be on paper that it looks very unlikely, but that doesn't mean you don't grant an evidentiary hearing. And we saw, McAfee's proclivities in that direction before. So we may see something, but it's very hard to fathom how, having lost removal, that he could win immunity. And that means Mark Meadows, who has basically done a slalom course better than anyone else, getting out of the contempt prosecution that the Congress recommended, getting out of, apparently being named as a co-conspirator in the 1-6 case, having a little bit involvement, but not being named at all in Mar-a-Lago. But push comes to shove for him in Fulton County, a state case. Trump can't pardon, etc. And we know all the problems with timing and the like. But, Trump could become president, and he could do a lot to scuttle federal prosecutions and to put on hold his own state prosecution. But I don't know if he can put on hold the prosecutions against others. So Meadows has rolled the dice successfully to date, but this is the big problem for him, and it continues, I think, to loom very large. And I think his latest effort to get immunity is probably going nowhere. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.